Maine voters already seem aware of that importance, with Republican Senator Susan Collins' reelection campaign in trouble, specifically because of how she votes in Senate confirmations for federal judges, including Supreme Court justices. The judge's ruling in this case came in a court case titled President Donald J. Trump versus Internal Revenue Service. The question before the judge was simply, was it a real case? Or was it a fake lawsuit brought by Donald Trump against himself, since Donald Trump is in control of the Internal Revenue Service and the United States Treasury, the two defendants Donald Trump was suing? As you heard from legal commentators on this program, including Andrew Weissmann, a lawsuit has to actually involve what a court calls adverse litigants, meaning the two parties actually have to be opposed to each other. Andrew has pointed that out repeatedly about this lawsuit. The judge determined today that this lawsuit did not actually involve two sides, but was really Donald Trump just suing himself. And in her 56 pages of dismantling the Trump fake lawsuit piece by piece, Judge Williams patiently waited until page 43, just exquisite work as a dramatist, page 43, to use the smoking gun given to her by the stupidest litigant in history to ever sue himself.
I'm sort of suing myself. I don't know. How do you settle the lawsuit? I'll say, give me X dollars, right?
Right. And so, on page 43, the judge writes, certainly a court should not be a forum for a party that cynically views a lawsuit as a vehicle to achieve a predetermined outcome. I'm suing myself. Quoting Donald Trump there from that appearance. In the rare cases where judges are forced to figure out whether the parties are really adverse to each other in a lawsuit, they pretty much never have the plaintiff in the lawsuits saying publicly on television, I'm suing myself. That is Donald Trump's unique contribution to the history of this kind of case. And yet another demonstration at the same time of the reason why careful litigants never say anything publicly about their cases. And the stupider the litigant is, the more dangerous it is to say anything publicly about their cases. The judge found that the lawyers on both sides of the case abused judicial process in order to set up a structure in which Donald Trump could be granted a generous settlement by his own Justice Department in a case that was fake to begin with. It was a way for the Trump government to give Donald Trump $10 billion. Donald Trump sued the Internal Revenue Service and the Treasury for $10 billion because a contractor for the IRS released portions of Donald Trump's tax returns to the news media several years ago. Even though Donald Trump filed the lawsuit after the statute of limitations had passed, the Justice Department that he controls did not object in court to a lawsuit being filed after the statute of limitations had passed, something the Justice Department has done in all similar lawsuits. The judge called the lawsuit performative litigation. Judge Williams carefully grounded her findings in Supreme Court cases written by Donald Trump's allies on the Supreme Court, including recent Supreme Court cases, affirming the Republican legal position that every person working in the executive branch is under the direct control of the President of the United States and therefore acting for the President of the United States. The judge quoted a Supreme Court opinion issued just last month saying Article 2 requires that the President control all executive power, especially the authority wielded by agency heads who are the most important of the President's subordinates and who must be the President's alter egos in their agencies. The judge said Donald Trump was suing his alter ego, Treasury Secretary Scott Bessent, and that the case was settled by his other alter ego in the case, Acting Attorney General Todd Blanche, who previously served as Donald Trump's criminal defense lawyer, which left him, Blanche, in a decision-making position reeking of conflict of interest in this case. The judge's opinion implicitly turned on the assumption of abject and absolute cowardice on the part of Scott Bessent and Todd Blanche. The judge wrote, Secretary Bessent in particular is subject to President Trump's actual and direct control in both of his representative roles. First, as Secretary of the Treasury Department, Bessent is a member of the President Trump's cabinet. In this role, Secretary Bessent is the president's alter ego in the matters of the Treasury Department. Second, President Trump's actual control over Secretary Bessent is grounded in statute. The Internal Revenue Code establishes that the Department of the Treasury, a commissioner of Internal Revenue, shall be appointed by the president. The Internal Revenue Code also provides that Bessent, in his role as acting IRS commissioner, may be removed at the will of the president. The judge wrote essentially the same thing about Todd Blanche being Donald Trump's alter ego at the Justice Department and instantly removable by Donald Trump. But what the judge left out entirely is that we have had cabinet members in this country who do not live as cowards in the cabinet, as all Trump cabinet members do every single day. When Republican President Richard Nixon gave Republican Attorney General Elliot Richardson a technically legal order to fire the special prosecutor investigating President Nixon, Attorney General Richardson refused to carry out that order. Attorney General Richardson did not break in cowardice under an order issued by a criminal president. Instead, Elliot Richardson did something that Scott Bessent and Todd Blanche could never do. They could never, ever have the courage to do it. Elliot Richardson drew a moral line. Attorney General Richardson said no to the President of the United States, and he resigned. And the next person in the Justice Department, Richard Nixon, tried to get to carry out that order, also refused and resigned. And because there was a time in our government then when honor came first. Among Republicans, honor came first. Elliot Richardson was a proud lifetime Republican. The third member of the Justice Department who Richard Nixon ordered to fire the special prosecutor did exactly what the president wanted, very obediently, and that decision came to follow Robert Bork for the rest of his life. When President Ronald Reagan nominated Robert Bork to the United States Supreme Court, 58 senators voted against Robert Bork, including 6 Republicans. Robert Bork discovered the hard way that in those days, there was no future in dishonor. Elliot Richardson set a standard that no one in the Trump regime would ever consider even trying to live up to. And Judge Williams knows that. And so she correctly assumes that defendant Scott Bessent in this case is under complete control of Donald Trump every minute of the case and every minute of his life. The judge can see what everyone in America can see when the Trump cabinet is gathered on TV to publicly worship him. Every member of the Trump cabinet was chosen for their flawless cowardice. And the judge made the point that Justice Department lawyers who were supposed to be defending the Treasury and the Internal Revenue Service in the lawsuit were also under the complete control of Donald Trump in the case. So Donald Trump was really suing himself, which is illegal. He tried to get $10 billion for himself by suing himself. Donald Trump's lawsuit asked Donald Trump's Treasury Secretary for $10 billion of taxpayer money to give to Donald Trump. And there was no attempt to change the terms of that lawsuit while it was suffering for weeks under constant public attack for trying to give Donald Trump $10 billion. Even Republicans in Congress refused to defend Donald Trump's attempt to simply seize $10 billion for himself from the United States Treasury. But the lawsuit eventually became politically untenable, and that is when Todd Blanche took it upon himself for everyone involved in the case to simply end the lawsuit and create a $1.776 billion fund not to pay Donald Trump and his family, but to pay the people who attacked the Capitol to try to help Donald Trump overturn the results of the 2020 presidential election, to pay them all for all the suffering that they endured as a result of being prosecuted for trying to beat police officers to death and threatening to kill the Vice President of the United States. The so-called settlement was signed only by Todd Blanche. No lawyer representing Donald Trump as the plaintiff in the case dared to even put his name on that so-called settlement document. On page 36, Judge Williams said, Acting Attorney General Blanche's apparent capacity to speak for both plaintiffs and defendants signed a settlement document on behalf of all parties to this action and then repudiate part of that agreement demonstrates that there was only one party whose interests were being represented throughout the case. Todd Blanche eventually announced that the $1.776 billion fund would not happen. No one would get paid. The judge wrote, the court finds that this matter was brought for an improper purpose to gain the imprimatur of judicial legitimacy for a settlement that had no viable basis in law or fact. As was observed in another matter brought in this district, this case is part of Mr. Trump's pattern of misusing the courts to serve political purposes. The judge then sanctioned the lawyer who filed the lawsuit, quoting a Supreme Court ruling that said the filing of complaints, papers, or other motions without taking the necessary care in their preparation is a separate abuse of the judicial system subject to separate sanction. Baseless filing puts the machinery of justice in motion, burdening courts and individuals alike with needless expense and delay. Even if the careless litigant quickly dismisses the action, the harm triggering Rule 11's concerns has already occurred. Donald Trump's lawyers dismissed the case in order to try to pull it away from this judge's jurisdiction and inspection of the case. The judge quoted the Supreme Court, saying if a litigant could purge his violation of Rule 11 merely by taking a dismissal, he would lose all incentive to stop, think, and investigate more carefully before serving and filing papers. And the judge wrote, plaintiff's attorney, Alejandro Brito, is referred to the Florida Bar for its consideration, review, and determination as to whether any disciplinary action is appropriate in light of the findings and rulings made in this order. And the judge said the parties are prohibited from referring to the purported settlement agreement or using, offering, admitting, or citing any of its provisions in any judicial, administrative, regulatory, arbitration, or any other official proceeding as evidence of a settlement reached in this matter. Finally, the clerk of court is directed to mail a copy of this order to the State Bar of New York, of which Acting Attorney General Blanche is a member, and to the District of Columbia Bar, of which Associate Attorney General Stanley Woodward is a member, where disciplinary proceedings are currently ongoing. Judge Williams said that the Trump lawyers acted in bad faith on both sides of the case. She wrote, bad faith is present if a court determines that fraud has been practiced upon it or that the very temple of justice has been defiled. Donald Trump has defiled Washington for years now in more ways than we can count, including recently defiling the very structure of the White House by swinging a wrecking ball at the historic East Wing of the White House, by defiling the reflecting pool. In the face of so much of the wreckage Donald Trump has visited upon Washington, the law has been powerless. But not today. Not today. Today, Judge Kathleen Williams said what no Trump cabinet member could ever say to Donald Trump. Judge Williams said no. And so this time Donald Trump lost in court in every possible way he could lose in court today. And this time, Donald Trump and his cowardly Treasury Secretary and his now sanctioned lawyers, this time, will not be allowed to defile the very temple of justice.